If your H-1B petition got frozen because of Trump's $100,000 fee, a federal appeals court just handed employers a reason to unfreeze it. But before anyone books a flight or quits a job overseas, there are three separate steps still standing between you and actually getting to the U.S., and this ruling only touches one of them. If you are outside the United States and a U.S. employer is preparing or has paused a new H-1B petition for you because of the extra $100,000 payment, a federal appeals court order issued on July 24th may change that plan. But this does not mean your visa is approved, every H-1B fee has disappeared, or the legal fight is over. As of July 25, 2026, the United States Court of Appeals for the First Circuit has denied the Trump administration's request to keep the $100,000 payment policy in force while the appeal continues. The lower court had already set aside the agency policy used to carry out that payment. The appeals court has now refused to pause that ruling. This may allow some employers to revisit delayed overseas hiring plans, but all normal H-1B rules remain, and filing without checking the latest court status could create an avoidable problem. In this video, we will explain what changed, which overseas workers may benefit first, who is probably not directly affected, what remains uncertain, and what an employer should check before filing. First, let us separate the new court order from the larger appeal. The case is called State of California versus Mullen. On July 24, 2026, the First Circuit entered an order about a request called a stay pending appeal. A stay is a temporary pause. The government wanted the appeals court to pause the lower court's June 8 ruling that would have allowed the payment policy to remain in use while the full appeal continued. The First Circuit denied that request. In simple words, the appeals court did not allow the government to keep the lower court ruling on hold. The district court judgment setting aside the agency policy is therefore back in effect under the current court posture. However, the appeals court did not issue a final ruling on every part of the case. It decided only whether the lower court judgment should remain paused during the appeal. The main appeal can continue, and the government may still seek further review. That is why it is accurate to say the extra payment is blocked again. It is not accurate to say the payment has been erased forever. Another court order could change the position later. Now, let us look at what existed before this latest ruling. Before September 2025, employers already paid normal government fees when filing H-1B petitions. Those costs depended on the type of petition and the employer. The disputed policy did not replace those fees. It added a separate payment of $100,000. On September 19, 2025, President Trump issued a presidential proclamation. A proclamation is an official presidential action. It was called Restriction on Entry of Certain Non-Immigrant Workers, and it took effect on September 21, 2025. Though the policy was aimed most directly at new H-1B petitions involving workers outside the United States, it directed the government to restrict certain petition decisions and entry when the extra payment was missing. It also allowed limited national interest exceptions for certain people, companies, or industries. The White House later said the payment did not cover earlier visas or petitions, did not change renewal fees, and did not stop current visa holders from normal travel. This court case, therefore, concerns the added $100,000 payment policy. It does not remove all H-1B fees. It does not cancel the H-1B program. It does not approve every overseas worker, and it does not change every current H-1B case. Here is a simple example. Imagine a software engineer named Aisha who lives outside the United States. This is only an example. A small American company wants to hire her and sponsor an H-1B petition. The company can manage the normal filing costs, but it cannot add another $100,000. Because of that added cost, the company pauses the plan. Under the current court position, the company may now revisit the case again because the agency policy used to enforce the extra payment has been set aside. But Aisha has not received an H-1B approval. The company still needs a real job, a proper petition, the required proof, and all normal fees. If the petition is approved, Aisha may still need an H-1B visa from a United States embassy or consulate. The court order changes one disputed payment issue. It does not complete the whole immigration process for her. Now, let us look at who may feel this change first. The most direct group includes employers planning new petitions for workers outside the country. Some may now revisit hiring plans that were stopped by the added cost. But the worker must remember one key fact. The employer files the H-1B petition. The worker does not normally file a new petition alone. The original payment policy also placed the payment duty on the filing employer. If a recruiter tells you that you can personally buy an H-1B approval by sending one $100,000 payment, treat that claim with great caution. No private payment can guarantee a real job, a petition approval, a visa, or entry into the United States. People already inside the United States may be in a different position. The original policy focused most directly on workers outside the country, and the official guidance said renewals were not changed by the added payment. A current H-1B worker seeking an extension is therefore not in the same position as a new overseas worker. An F-1 student seeking a change of status inside the United States may also follow a different filing path. But location alone may not answer every question. A petition can request different types of processing. The employer should review the exact filing request instead of assuming that every person inside the country is automatically outside the issue. There is another point many headlines leave out. The court blocked the agency payment policy. It did not remove the normal H-1B eligibility rules. An employer must still show that the offered job meets H-1B requirements. The employer must still submit the correct petition and supporting records. A case subject to the annual H-1B cap may still need a valid selection before the full petition can be filed. The worker's education still matters. The job duties still matter. The employer's business and ability to offer the job still matter. The required wage and other filing rules still matter. Imagine that Aisha's employer decides to move forward. If the job description is weak, the worker's degree does not fit the role, or the company cannot support the petition, the court order will not fix those problems. Removing one disputed payment does not create H-1B eligibility. What is confirmed is that the First Circuit denied the government's request to keep the district court judgment paused. What remains uncertain is how the full appeal will end and whether another court will later change the current position. Before I walk you through the exact steps an overseas worker and employer should take right now, if you're finding this useful, go ahead and subscribe so you catch these breakdowns as soon as they drop. This leads to the most important practical point in the video. The legal position has already changed more than once. On June 8, 2026, the district court declared the agency policy unlawful and set it aside in its entirety. The government appealed. The district court then placed a short administrative pause on its own ruling while the First Circuit considered the government's emergency request. On July 24th, the First Circuit denied the request for a longer stay during the appeal. This means the district court judgment is no longer being held back by that temporary pause. This is where an avoidable mistake could happen. One employer might send the extra payment even though the agency policy is currently set aside. Another employer might assume the issue is permanently finished and ignore a later court update before filing. The employer should check the newest official USCIS instructions, any current agency notice, and the latest court status. If the filing system gives unclear directions, the employer should not guess. Qualified immigration counsel can review the exact case before it is submitted. Keep a complete copy of the petition, payment records, delivery proof, and every USCIS notice. What about employers that already paid? The July 24th order does not create an automatic refund system. It does not explain when money already paid will be returned or whether every payment will qualify. An employer that already paid should keep the receipt, petition copy, payment confirmation, and agency notices. It should wait for official instructions or seek case-specific advice before expecting a refund. Now we come to another difference that every overseas worker must understand. A petition approval, a visa, and admission into the United States are three separate steps. USCIS generally decides the employer's H-1B petition. After an approved petition, a worker outside the United States may need to apply for an H-1B visa through the Department of State. A consular officer then decides the visa application when the worker travels. Customs and Border Protection decides whether to admit the person at the port of entry. The July 24th order does not guarantee any of those later decisions. It does not order a consulate to issue a visa. It does not remove normal screening. It does not promise admission at an airport. It also does not create a faster interview or a special appointment. For Aisha, this means the employer may be able to restart the petition without planning for the disputed payment under the current court position, but she may still need to complete the visa application, attend an interview when required, answer questions truthfully, and provide the required documents. She should not resign from her current job or buy a non-refundable ticket just because the payment policy is blocked. Major decisions should come after the required approvals and after the employer confirms the real start plan. There is also a long-term point to understand. Some workers use H-1B status as one step toward a later employment-based green card. This order may help restart the first step, but it does not change green card rules, visa bulletin dates, country limits, or permanent residence requirements. There is no single backup visa that fits every worker. Another category may fit some people, but no option is automatic. Our goal is to explain major changes without turning uncertainty into fear. So, let us correct the most common rumors around this decision. Some posts may say every H-1B fee is now gone. That is false. This case concerns the added $100,000 payment policy. Normal petition fees and other lawful costs still remain. Another claim says all overseas H-1B applicants are now approved. That is also false. The court order does not create a cap selection, petition approval, visa approval, or entry permission. Every case must still meet the normal rules. A third claim says the payment has been canceled forever. That is not confirmed. The government lost its request to keep the district court judgment paused during the appeal. The appeal itself has not received a final ruling. So, what should a careful overseas worker do now? Speak directly with the real sponsoring employer. Ask whether the company paused the case because of the extra payment. Ask whether the employer or its lawyer has reviewed the July 24th order and the current USCIS filing instructions. Keep your passport, degree records, transcripts, work letters, licenses, and job documents organized. Make sure every record is true and complete. Do not alter a letter, invent work history, hide a fact, or send false information to make the case appear stronger. If a petition is already pending, keep checking the official case account and read every notice. Do not miss a response deadline while waiting for another court update. The payment dispute does not pause a deadline written on a USCIS notice. If the petition is approved and you need a visa, follow the Department of State instructions for the embassy or consulate handling the case. Give truthful answers and bring the required documents. Petition approval does not remove the visa application process. Employers should separate new overseas cases from renewals, extensions, and other filings. They should identify which cases were delayed only because of the extra payment. They should then confirm the current fee rule before each filing because the court position may change again. Do not send $100,000 to a recruiter, agent, or unknown person who says the payment guarantees a visa. Do not file only because a viral video says the fee is gone. Do not assume another worker's case has the same facts as yours, and do not make a major travel, work, or financial decision based only on one video. Now, take a calm step back. Most current H-1B workers are not losing status because of this court order. Previously issued visas were not canceled by the original payment rule. An overseas worker is also not facing an automatic denial only because this legal fight exists. The realistic position is that the July 24th decision removed the temporary pause that had kept the agency payment policy in effect during the emergency review. This may reduce a major cost for affected new overseas cases. At the same time, the normal H-1B process remains, and the appeal can continue. For some workers and employers, this decision may reopen a plan that seemed financially impossible, but careful planning still matters more than fast action. Check the current rule on the filing date. Keep complete records, protect every deadline, use the correct petition process, and wait for the required approvals before making major life changes. This information reflects what was available as of July 25, 2026. Immigration rules, agency instructions, and court orders can change. This video provides general information and is not personal legal advice. Every case has different facts. Anyone facing a filing deadline, denial, status problem, fraud concern, criminal issue, removal case, or another complex matter should speak with a qualified immigration lawyer or an accredited representative. Follow for more updates like this one, and subscribe to the channel so you don't miss what's coming next.